This Civic Media podcast is sponsored by UW Organ and Tissue Donation. Organ donations are desperately needed, and now is the right time to become an organ donor. Talk to your family. Get the dot. Save lives. Go to heroicdeed.com.
Welcome to Amicus, a law review with Jim Santel. Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
Welcome to this, our weekly weekend venued broadcast. My name is Jim Santel, and yes, I'm the host of Amicus, a law review. Delighted and honored that you have chosen to join me this weekend for this, our broadcast to and out throughout the state of Wisconsin in the broadcast stations of Civic Media. We take our name, as always, our adopted commission to conduct a review, our analysis, some deliberations, some consideration of the recent news of our times from the word amicus, meaning friend of the court, a person, an individual, an entity that somehow assists in understanding, in appreciation, assessment of some relevant issues that need resolution, disposition, and so consistent with the notion, the Latin word amicus, the legal word amicus, we'd like to think that we are your friend in providing you with some of those important insights that are relevant to your own assessment of your lives and your livelihood in the all-important areas of law and government and the aspiration for justice. Welcome to Amicus, a law review. With me in the broadcast station of Civic Media is my fantastic producer, Jess. And indeed, she is animating not only the practical aspects of our production this weekend, but as you're going to hear, also has inspired at least one of our major segments in the second hour, having to do with the rule of law, some lessons from overseas. In that connection, let's talk first about the syllabus, the academic agenda before us in Amicus, a law review this weekend. We're going to begin, of course, with the significant breaking news that amends and adjusts in many ways the news we talked about last week, which was the initial decision by the president-elect to nominate Matt Gaetz as the Attorney General, the Chief Federal Law Enforcement Officer for the United States of America. That, of course, overtaken just this past week by the news that Matt Gaetz is no longer going to be that nominee, pulled himself out of consideration for all sorts of good reasons that we've talked about on this broadcast and others. And instead, within moments almost, the president-elect Donald Trump identified a new pick, a new selection, a new likely nominee for the Chief Federal Law Enforcement position in our nation. Her name is Pam Bondi. She's the former Attorney General of the state of Florida. We're going to talk about Pam Bondi. We're going to give you some insight into who she is, where she comes from, what her experiences have been. It is important for all of us to appreciate this, again, because of the significance of what she is going to be supervising, a budget of nearly $38 billion, 40 different units, nearly 115,000 employees. We'll tell you more about Pam Bondi as we think about the encumbering of that all-important position at the top of the Department of Justice. That coming up first on our agenda here on Amicus. Then we're going to go to the other major rule of law story of just this past week, and that is the decision by Judge Juan Merchan not to proceed next week with the sentencing of Donald John Trump. Donald John Trump, as you know, convicted back in May of 34 counts of violations of New York law, felonies in the state of New York. This past Tuesday, we anticipated some major action by Judge Merchan in terms of his deciding on this all-important issue related to the applicability of that Supreme Court case, finding that presidents can commit crimes in office, the executive immunity decision. He was scheduled to announce his decision on that on Tuesday and then presumably continue with his oversight of the case by sentencing the president-elect the following Tuesday, this coming Tuesday, the 26th of November. Instead, major news of what did not happen. And that is, not only did Judge Juan Merchan not issue that opinion, but he took off his calendar the sentencing scheduled for this coming week, the 26th. We'll also talk about what the district attorney, his name is Alvin Bragg, did in connection with that, his advocacy about what should happen next. And yes, you're going to hear again my own sense of outrage and of dismay and of great discouragement when it comes to the rule of law in this setting, that we're not completing that litigation, that prosecution, bringing it as it normally should be brought to a conclusion, at least in the trial court, with what? A sentencing. That's what we do in America. After a defendant has been convicted of a crime, we sentence that defendant. We'll talk about what exactly it is that Juan Merchan did not do, what it is that's happening there in the Manhattan criminal court, and what we can expect, if anything, in the future from the disposition of that singular case that went to trial with respect to our president-elect, and what we can anticipate for the future of that case and the other three cases, which we have also talked about, that other state case in Georgia, the other two federal cases, one, of course, the election interference case in Washington, D.C., and then the Mar-a-Lago classified documents case that's pending in South Florida. The upshot of all of that, no spoiler alert here at all, simply an affirmation that all of those cases going to end not in clear dispositions, but whimpers. And we'll talk more about that. And then going into our second hour here on Amicus, a law review, lots of lessons from overseas. We, from time to time, go overseas to get some sense of rule of law, the administration of justice, and what does government do in foreign countries. This weekend, we're going to take a look at Brazil, some significant prosecution recommendations for the former president of the Brazilian nation. His name is Bolsonaro. As you well know, we have talked about him before. We're going to talk about also additional rule of law lessons and insights for America coming out of Hong Kong. Some major sentencings this past week. 45 people sentenced by the Beijing-led judiciary there, sending them to prison for anywhere between 4 and 10 years for pursuing the rule of law there, for exercising their right to vote, organizing a primary election. And we'll talk all about the lessons, the horrific lessons there, about what can and has happened in that autocratic state to undermine the basic trappings of what every person should be able to do, that is, have representation in their government after voting. Not in Hong Kong, shutting down this past week that major effort by many people there to ensure the continued independence, if that has been the case at all in recent years, at least the independence when it comes to choosing elected officials in the Hong Kong legislature, that brought to an end. And then, again, recommended many weeks ago by my wonderful producer, Jess, we're going to return to a story that we talked about at great length, and that is the devastating rape trial in France. This is their version of the O.J. Simpson litigation. This case has been going on for 3 months. We're going to talk about some significant things that happened just this past week, including testimony from the family, the victim family, the family of the principal defendant, who is charged with engaging in absolutely, positively horrific behavior with respect to his wife, inviting others in to assault her sexually, the impact of that conduct now being played out in that French courtroom, understanding the significance of the victimization, and also pulling from that, as we've done before, some important lessons about what trials can and should do, not to completely erase the past. That can never happen. The imperfect results, of course, of a criminal trial, but the operation of justice, to bring to justice those people who would violate our basic norms, our basic standards of human behavior, and therefore compromise the safety and security of all of us. We're going to be talking again more about that French trial that continues to this day in that important nation. An ally of the United States of America also has something to teach us here in the United States about the meaning and the significance of trials and dispositions in a week when, in this major case coming out of Manhattan, we have seen none. All of that is coming up on Amicus, a law review. Thank you once again for joining me and Jess as we pursue all of these issues here on our weekend show. Let us begin then. Let us begin then with the major news about a person who is likely going to be our chief federal law enforcement officer. We know well now that in the good wake of Matt Gaetz's departure, a nomination that was probably doomed from the start. No credibility there. Stunning, if you will, that any president-elect would identify someone with no qualifications to do the job. And all of that is even charitable to call it baggage. But all of that information about his past behaviors, his violent criminal behaviors with respect to engagements, sexual engagements with minors, behavior that would otherwise have put him probably inside a federal courtroom, but for some compromises and some concerns about the prosecution that was abandoned by the Department of Justice many years ago. Nonetheless, that is his background. And as more and more information coming out about that became clear, even as the vice president and others attempting to continue to support that nomination, clear that it would fail, and it did. And Matt Gaetz withdrew his name from the president's set of nominees. And in almost instant follow-up, the president-elect identified Pam Bondi, B-O-N-D-I, Florida's former top prosecutor, as his next nominee, not yet nominated, but will be nominated to serve on his Department of Justice as the chief federal law enforcement officer. Let's talk about what we know about Pam Bondi. She is 59 years old, and she, again, is a longtime loyalist, undeniably, of President-elect Trump. She served on his legal team, not the head of the legal team, but the legal team nonetheless, in that first impeachment trial, and currently heads the legal team of something we've talked about here on this broadcast called the America First Policy Institute. You may recall our discussions of that in connection with the Heritage Foundation and all sorts of proposals for what a new Trump administration would show. We're going to talk more about Pam Bondi's contributions to that process, her history, and the other things we should know and the Senate Judiciary Committee should know as it takes up in the weeks ahead the nomination of Pam Bondi to be our Attorney General here on Amicus, a law review.
You're listening to Civic Media. You can tune into any of our live shows on any radio station across the state with the Civic Media app. Find us in your phone's app store and listen anytime, anywhere.
This is Amicus, a law review. My name is Jim Santel. I am your host this hour and next hour as well, joined in the studios of Civic Media by my fantastic producer, Jess.
Hello.
And just delighted to be with you this weekend. As always, it's been a little while. So pleased to discuss with you, both on the air and off, some of these major stories in the areas of rule of law, especially recently.
Yeah, it's been a busy few weeks here.
It has been. And I wonder again, as I've often said to you, you and I are, I think, in many ways cut from the same cloth, although we are from different generations,
yes.
Plainly. I am much older, I'm an old person. I'm wondering your particular perspective on frankly, any of this, but especially the issues related to the selection of an attorney general, the importance of that position for anyone, but especially someone in your professional category and your professional status here in 2024 and 2025.
Absolutely. Well, we did get a new measurement of time out of this whole attorney general nomination business. So that's interesting. For those of you who may be wondering, if you ever need to refer to an 8-day period, you can just go ahead and call that a Gaetz.
A Gaetz. Right, exactly. It's a new measurement. It's not metric system. It's a Gaetz system, right?
Americans will use anything but the metric.
Right. Exactly. Very good. And we will chat more with Jess throughout our broadcast this weekend. Again, delighted to be in partnership with her this weekend, as always, as we talk about the Attorney General. This Attorney General, presumably after nomination, will last more than 8 days, right, Jess? And will continue to serve in that capacity. So we should know something about her. We know, as I indicated before, that she was a part of Donald Trump's legal team during the first impeachment proceeding. Obviously, she and the other lawyers successful at that time, keeping him from a conviction in the United States Senate. You may recall that first impeachment based not upon the Russia matter, but based upon the outreach, the engagement by then President Trump with Volodymyr Zelensky and soliciting from him some assistance in investigating a family called the Bidens. And that resulted in that first impeachment set of charges. It goes to trial before the Senate. Pam Bondi was there in the floor of the Senate representing Donald Trump, which again brings her into partnership, if you will, with the others also nominated or to be nominated by this president to serve in other capacities. Other people have also had that attorney-client relationship with him. We've talked about that before, and the concerns that raises in connection with whether or not we can anticipate an arm's-length relationship between the White House and the Department of Justice when the relationship has been just that close.
Well, so my question here for you is there precedent for this of a president-elect choosing someone who has actually represented them and nominating them for this chief law enforcement position?
And the answer is, in part, that while I cannot speak to every single attorney general, there have been 86 of them during the course of our wonderful history. Certainly in recent times, there have been situations where our presidents have known their attorneys general, but I am hard pressed, Jess, during the period that I was with Department of Justice to think about a situation where any of these attorneys general actually represented a president, certainly not in a criminal proceeding.
For
and that's what we have.
Impeachment. I mean, this wasn't because of, running a red light.
Exactly.
This was being impeached from the presidency of the United States.
No small thing. And so, again, we have more unprecedented events going on here. Issues for the Senate Judiciary Committee planning to take up. In addition, right now, she is leading this group called the America First Policy Institute, which also has produced some documents that give a lot of animation to this incoming administration. Like the Heritage Foundation has published its own set of principles that they would like to see the new president embrace, including a lot of things related to the Department of Justice and government generally, including, as we have seen in the past, statements made by the president-elect, his interest in getting rid of the civil service and turning all of the employees, presumably all of them in the federal government, into at-will employees, subject to termination, firing, if in fact the president do something the president does not especially care for. That is also a dramatic impact upon the entire federal workforce, but including the Department of Justice as well. In addition, just to those things that we already talked about, it is important to note that Pam Bondi also oversaw the filing of many, if not all, of those lawsuits that followed the 2020 election. She was at the forefront of those lawsuits in those battleground states around the nation, advocating in those situations that, in fact, the 2020 election had been stolen, And she continues and has continued to articulate that view, even as she has been a surrogate and a mainstay personality in the recent campaign for this president. She has appeared for him in many venues around the country, and now going to be likely the nominee to serve in this top spot. She grew up in Tampa, Florida, the suburbs, young prosecutor with the Hillsborough County State Attorney's Office, frequently appeared even way back then on local television before she ran for State Attorney General as a Republican in 2010. Served for a couple of years in that situation, and it is important to note that during the course of her time as the Attorney General, she became the face just of a lot of issues that I suspect are near and dear to you, to me, to many of our listeners, and that is one of those. She became the face of the opposition to same-sex marriage in Florida.
Yes, she did.
She was defending a statewide ban that voters had passed in 2008. She said that she was obliged to do that because it was in the state constitution.
Regardless of being right or wrong.
Right. Exactly. The fundamental issue. And you've got an Attorney General who should, in fact, just to your good point, should, in fact, be animated by those fundamental principles, right? It was only after that mass shooting, which we all recall, that horrific mass shooting, the Pulse nightclub in Orlando in 2016, that Pam Bondi adopted a somewhat more conciliatory tone toward the LGBTQIA community. And nonetheless,
this is not a warm and friendly relationship. This is still very much at arm's length.
Absolutely. Absolutely. And again, probably in many ways because of the locality of it, you have this absolutely horrific event visited upon all Americans, including the LGBTQIA community there in Orlando. An attorney general should be sympathetic to any horrific thing like this, but she certainly had previously articulated a view that same-sex marriage should not happen in Florida. She focused, to her credit, on combating drug abuse, child trafficking. She also, however, was a part of the partisan legal fight against, that's right, the Affordable Care Act, known as Obamacare. We're going to talk more about Pam Bondi as Amicus, a law review, continues here on the broadcast stations of Civic Media. Stay with Jess and me for all of that and much more.
You're an organ donor, right? Well, here's a tragic fact. Approximately 20 people die each day waiting for precious donated organs. You could make a life-saving decision simply by getting that important dot on your driver's license. That little dot shows those who need to know that you've made a decision to donate organs at a critical time. Go to heroicdeed.com to learn more about the importance of organ donation and how you can make your wishes known. Talk to your family. Get the dot. Save lives. heroicdeed.com.
This is Amicus, a law review. My name is Jim Santel, your host this hour and next hour as well here on the broadcast stations of Civic Media, joined in the station by my outstanding producer, Jess. Delighted to have her be a part of our conversation this weekend about all of these important rule of law issues, including a review, an initial review, an assessment of the likely incoming Attorney General of the United States of America, her name Pam Bondi, talking about some of the positions that she has taken in the past. They are relevant to understand who she is and what she may do in connection with her new duties coming up in Washington, D.C., in addition to identifying some very legitimate legal fights in terms of promoting the safety and security of people in Florida, focusing again upon drug abuse and child trafficking, those kinds of things. Significant that she also led one of the major fights continued to lead fights against Obamacare, the Affordable Care Act. She also opposed during her tenure the legalization of medical marijuana, opposed that as well. Other things during the course of her tenure are significant. And one of those goes directly, from my perspective, to questions that once again should be asked of her when she is appearing before the Senate Judiciary Committee, determining whether or not she should be confirmed by the United States Senate. Now, Jess, you may recall well, I know you do because I know you're the student of the news, that there was a time in America when our present and our future president, our president-elect, Donald Trump, had in place something called Trump University.
Yes, I know where this one's going. I did some research on Pam Bondi today.
And so you know that I'm guessing, Jess, that you are not a graduate of Trump University.
I hold a degree from the highly accredited University of Wisconsin-Milwaukee.
Outstanding. Of course, a hugely important and underscore legitimate and wonderfully academic institution right here in Wisconsin. Trump University, unfortunately, does not have the credentials of a University of Wisconsin-Milwaukee. And we knew that probably from the start, focusing ultimately upon real estate and property issues. An awful lot of people early on saying, gee, I'm attending this university. I'm paying tuition, lots of money.
Hefty tuition, right?
And ultimately saying, I'm not certain I'm getting the education that I would get at a University of Wisconsin-Milwaukee institution. And reporting, among other things, one of them, for example, began to complain about this, said, gee, I don't know that advice from my professor that one of the ways that I should become a real estate agent, a good real estate agent, is simply to increase the credit line on my credit card. That was the kind of instruction being given. And so ultimately, this, of course, attracts the attention of an awful lot of people. Appropriately, students reach out to their attorneys general in states around the country because they've enrolled in the Trump University. And those students are around the country. Many, many attorneys general take notice of the fact that there is a trend here, that people are having problems not just graduating from Trump University, but even getting a basic education there. And ultimately, they investigate. And to cut somewhat to the investigative and civil prosecutorial chase on all of this, they ultimately determine that Trump University really is a product of fraud.
It is a scam.
It is a scam, and that regrettably, they're victims of that scam, as you have appropriately identified, Jess, and those victims are the students. And it is the responsibility, of course, of attorneys general throughout the United States of America, including right here in Wisconsin, in Florida, which gets us closer to Pam Bondi, all of them on behalf of the victims, the constituents in their states, to try to address the kinds of fraud, the scam events that were going on inside of Trump University. So the attorneys general, not all of them, but many of them across the country, get together and file independent lawsuits, collaborative lawsuits. Ultimately, Donald Trump and Trump University required to pay as damages $25 million with an M dollars to try to compensate to some, not all perhaps, and imperfectly compensating the students of this fraudulent university. Along the way, initially, Pam Bondi's Attorney General office is a part of that investigation. And what happens is, as the decisions are being made to sign off on the complaints and get those pieces of litigation underway, Pam Bondi decides not to go ahead with her involvement on behalf of the victims, the student victims in Florida. And Jess, I'm guessing you know the reason why that might have been.
Well, yeah, it wasn't because she decided to investigate and didn't believe that there were legitimate claims here.
Instead, there's an awful lot to suggest because of the timing that in 2013, she got a donation from whom?
From Donald Trump, and a significant contribution of $25,000, if I'm not mistaken.
That's exactly right. You're not mistaken, Jess. And that is a significant political donation to keep her in office. And, of course, Pam Bondi at the time, when confronted with this, we didn't find out about it right away, but confronted with it, she said, we made an independent decision not to pursue this. Nothing to see here. The donation had nothing to do with the legitimate decision that she made. And in fairness, Jess, you and I both know, we've talked about this a lot on this broadcast to others. All the time, prosecutors have to make tough calls, both in the criminal area, the civil area.
As they should.
They should, right? That's the reason why we commission them to do this work. They make decisions based upon the law and the facts, whether the law will support it, the facts support it. And that's the point that you just made, Jess. The question is, and the question that needs to be asked about this matter, because it is relevant, it's highly relevant to the future encumbering of the Attorney General's position by Pam Bondi. What happened here? What about this particular circumstance? She plainly, I assume, would tell the members of the Senate committee that the one had nothing to do with the other. But the other part of this is the Senate Judiciary Committee should also look beyond just her testimony. The question is, and appropriate for the Senate Judiciary Committee to ask for documents, memorandums, subpoena those things if necessary, to find out, were there memorandums, what were the contemporaneous writings about this that may or may not have memorialized the exact reasons why she, as opposed to many of the other attorneys general, did not join this lawsuit. And here's the reason why all this is so important. All the other things are reasons for exploration or positions on past issues, and reasonable people can argue with her and others about some of that. This is a situation where the question is, are you motivated by politics?
Yes.
To make those important decisions, as in this case, the chief state law enforcement officer there in Florida. And if you've done that in the past, will you do that when you become the federal chief law enforcement officer? That's the question.
I think you can almost reword that and say, is there any reason to expect that you won't?
Your history has suggested that you're inclined to do this. And members of the Judiciary Committee on all sides of the political aisle deserve some answers from her. Not only, presumably, once again, she would commit to not doing it in the future, but it is a source of great, great concern. Again, not that the other matters are secondary. All of those things should be looked at. This one goes specifically to the judgment, the discretion, the integrity of the nominee.
Absolutely. Will she do the job of chief law enforcement officer in this country to advocate for the people who need justice?
That's exactly right. In so many ways, as we've talked last week, there are so many areas of the work of the Department of Justice that are critically important, not only to victims of crime, but victims of civil fraud, all sorts of other things that support and keep us safe and secure. Their operational units, the COPS office, the Community Relations Service we talked about, all sorts of investigative agencies, the DEA, the ATF, the FBI, litigation divisions, antitrust, tax, environment, all kinds of things that are critically important, civil rights to the future of America. We need desperately to have an attorney general in place who will understand not only the work that needs to be done in those areas, but will take an approach to it that has a complete sense of integrity, that if indeed the president at any time should pick up the phone and call her, as he did during the course of her continued relationship with him in all of these other areas, call her Pam and ask her to do something on his behalf. Will her allegiance be to the Department of Justice, more importantly, to us as United States citizens, or will it be to the President of the United States of America? That's the focus. That's got to be the focus of this nominee.
Absolutely.
And that's the reason why this particular matter, with respect to Trump University, many years ago, nonetheless remains relevant today and should be among the list of things that the president should be focused on as she makes that nomination. And also, most importantly, the people of the United States of America should be focused on as this nomination goes ahead. All of that coming up, obviously, in the future of our nation. We know that those nominees are going to be forwarded again, in this case, to the Judiciary Committee of the Senate, many other committees of the United States Senate taking up other areas. Yes, in the areas of education and national security and defense, all those kinds of things where we have other nominees who also deserve a great deal of scrutiny when it comes to determining in their advise and consent role, what should the Senate do And there have been, plainly, as we know, situations where the Senate has said, Mr. President, we do not agree. And nominees have to be rejected by the Senate. Again, a majority vote is all that it takes in the Senate to confirm or to reject, to send a nomination back to the White House with a request for a new nominee.
And that's a simple majority, just 51, right?
That is a simple majority. This is not a situation where you've got legislation that requires that infamous thing that you and I have talked about, Jess, which is the filibuster. That's the 60. That's the supermajority for nominees, including these nominees, of course, for the federal bench, including the United States Supreme Court. You need 51. In fairness to this nomination, here is what the president-elect said about it. He said, Pam will refocus the DOJ to its intended purpose of fighting crime with a capital C and making America safe again with a capital M, a capital A, a capital S, a capital A. He said that in a social media post announcing the selection. He said, I have known Pam for many years. And yes, indeed, he has.
Know.
That is one of the concerns about the nature of that relationship. How close is it? And can the president once again pick up the phone and call her to rely upon that relationship, an attorney-client relationship about which we should never and will never know anything. We shouldn't. That's the way the attorney-client relationship works. He said she is smart, she is tough, and she is an America First fighter. That's plainly a reference to her present role in the legal arm of the America First Policy Institute, who will do a terrific job as Attorney General, ! And again, in all of these situations, if indeed she is confirmed, it is a good thing, and we should anticipate that all of our nominees, including the Attorney General of the United States of America, we hope that they are successful. And successful, by that we mean with a small s, in promoting the interests of justice, of rule of law, of the good things that America should be all about. That's a successful Attorney General. And again, not someone who has a close relationship with the White House in such a way that takes instruction from the White House about the ways in which those prosecutions, civil, criminal, about how investigations should go, about how monies, the literally billions of dollars now within the control of the Attorney General, should be allocated and used well, thoughtfully, productively inside the U.S. Department of Justice. All of that coming up as we continue to think about nominations here in the United States of America in the incoming administration in just about 60 days or so. The other major news story, of course, comes out of New York City, not Washington, D.C., New York City, and that's the decisions coming out of the Trump trial there. Decisions by the presiding judge and by the district attorney. As Amicus Law Review continues, we're going to talk about that other major rule of law story, and again, underscoring my great disappointment with what just happened there. We'll explain exactly what that was as Amicus Law Review continues.
You're listening to Civic Media. Find the latest news, information, and archives of all your favorite shows on the Civic Media website, civicmedia.us.
This is Jim Santel. I am your host here on Amicus Law Review in the remaining moments of our first hour of our weekend broadcast, continuing into a second hour. And in connection with the continuing focus that we always have on the rule of law on this broadcast, let me resurrect an issue, a thought, a perspective that I first articulated in our broadcast last weekend, citing from a small but important writing of Professor Timothy Snyder from Yale University. He wrote a book called On Tyranny a number of years ago, long before Donald Trump was in our political national attention. He said 20 lessons from the 20th century about the circumstances, the things that all of us should do if we are concerned about the future of government. And just the number one principle, it is literally number one of the 20, is this. And it is relevant to our next news story here on Amicus. Timothy Snyder says this. He says, do not obey in advance. Do not obey in advance. And here's his commentary, much more extensive in the pages right after this, but this is his summary of that fundamental principle. He writes this. He says, most of the power of authoritarianism is freely given. In times like these, again, he was not referencing the times that we are speaking about right now, but it's certainly relevant to all periods of time. In times like these, individuals think ahead about what a more repressive government will want and then offer themselves without being asked. A citizen who adapts to this in this way is teaching power what it can do. Compelling words about not obeying in advance, not anticipating what a next government will do, and conforming your conduct presently to what may happen in the future, effectively conforming your conduct to abandon your fundamental principles about the rule of law, about due process, about even something as simple as basic criminal procedure. And that leads me, in the words of Timothy Snyder, with his commission about not obeying in advance, to get into our next story about what happened just this past week, Tuesday, in Manhattan. Jess, you know well, because we've talked about this as well, anticipating our being together for this broadcast this weekend, that I fully anticipated that in this broadcast we would be doing a dramatic reading of Judge Juan Merchan's order. And that order, Jess, as you know, was going to be this. He was going to describe the ways in which, presumably, that Supreme Court opinion issued on July 1, I have railed against it for many months and weeks now. That Supreme Court opinion finding that indeed there is a principle inside our Constitution that says that a president can commit crimes with impunity. The question, the homework given from the Supreme Court then to other judges in all these cases is figure this out. What does this mean with respect to all the other cases? And indeed, in the wake of that decision, July 1, of course, as we know, that landed likewise in the courtroom of Judge Juan Merchan. Now, Juan Merchan had weeks, actually months earlier, presided over that trial, the singular trial that proceeded against Donald Trump among all these four. In the wake of that, lots of very colorful testimony that we talked about and reviewed. America riveted to that in many ways that we haven't been riveted to a trial in a long period of time. In the wake of that, a jury duly constituted returned a verdict unanimously, beyond a reasonable doubt, that Donald Trump had engaged in, yes, that's right, 34 counts of violations of state law, false statements, false representations, fraud, in terms of putting together documents to do what? To cover up the fact that he and Michael Cohen, co-conspirators, other people involved directly and indirectly, to cover up the fact that he had had an affair long ago, and that if that affair was disclosed during the course of the 2016 campaign, that would plainly have an impact. That was the reason why that case, although it was sometimes referred to as the documents case, a sort of dry case, actually wasn't. It was actually an election interference case going way back to 2016. And so the assignment coming out of July 1 was, what do you do with that in the wake of the conviction in a case that is against a defendant who is not, at the time, the President of the United States of America? Juan Merchan initially, as we know, has scheduled the sentencing, which is what we do in America once there is a conviction, has scheduled the sentencing for Donald Trump on July 11th. That, Jess, as you know, is a week before the Republican National Committee met here in Milwaukee, right here. That's a
goodness. Was that months ago? Was that days ago? Was it years ago?
A long time ago, July 11th. And of course, what happens then is Judge Merchan says, okay, we'll take more time to figure out whether or not this homework assignment given to all of us by the Supreme Court to determine whether or not there's something about this state trial involving non-official acts of a person who wasn't even a president at the time. Does that apply? And so presumably an awful lot of people would say, no, there's no applicability to that. But Juan Merchan said, okay, I'll solicit from all of you some views about all of that. And in the meantime, what I'll do is I'll suspend the sentencing. I'll take that from July 11th. I'll put that instead into September. And he did that and said, I'm going to announce my decision, not only about the immunity decision, the immunity ruling, but also I'm going to reschedule the sentencing for mid-September. We'll do all of those things sort of in series, but close in September. And again, solicited views and perspectives from all the attorneys, counsel for the defendant, Donald Trump, for the prosecution. His name is Alvin Bragg. He's the DA there in Manhattan. And in September, again, Juan Merchan said, you know what? We're too close to the election. In the midst of this unique period in American history, I don't want to influence the election. I don't want to be viewed as being partisan in some way. And so I'm going to postpone this yet again. Mm-hmm. And he postponed the election and his decision, his predicate decision on this issue related to immunities. He postponed that until, let's all look at our calendars, November 19th. Yes, that's right. It was just past week, Tuesday. Mm-hmm. And said as well that I'm going to postpone the sentencing until November 26th, which would be this coming Tuesday. And that is the reason why just you and I and others here at Civic Media and around the country woke up on Tuesday morning and thought we were going to hear from Judge Juan Merchan, his announcement of this decision, and presumably telling us all that there's no applicability to this, of the Supreme Court case to his trial. He did not do that. And as the silence grew during the course of the morning hours in Manhattan, what happened was nothing. And when we come back here on Amicus Law Review, we'll tell you exactly what did and did not happen and the reasons why that result on Tuesday speak volumes about the rule of law in America and speak a lot to the criminal justice system with respect to one person in America who does have priorities and privileges that none of the rest of us has. All that coming up on Amicus, a Law Review.
Welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Amicus, a Law Review. My name is Jim Santel, and I'm your host for this, the second hour of our broadcast, talking all about, as we always do, the rule of law and government, courts, due process, all of those good things that our nation is all about. This past Tuesday in Manhattan, some challenges to those fundamental notions when, after anticipating that the presiding judge in that criminal case against Donald Trump, resulting in his conviction by a jury, 34 counts of violations of New York law, fraud in statements, fraud in representations, false statements in connection with his attempt to hide from all of us information that would presumably have been damaging to his 2016 campaign for the presidency. In the wake of all of that, in the wake of a several-week trial involving a jury of actually 14 people, ultimately 12 people deciding the case, court staff, witnesses coming in, judicial staff as well, lawyers, their staff coming in, the sentencing in that case after the return of the jury verdict, finding the defendant guilty of all of those counts, postponed repeatedly by Juan Merchan. Various reasons articulated along the way. And finally landing here in mid to late November, when Juan Merchan promised both a statement, an order, an opinion on the extent to which, if any, the Supreme Court case on immunities affects his capacity to continue to oversee the case and to impose judgment, a sentence upon Donald Trump. A decision that, interestingly, others have not had much difficulty in coming to resolution on. We know that during the course of all of these proceedings, Donald Trump at some point asked a federal judge to exercise jurisdiction, basically to remove the case from Judge Juan Merchan's state courthouse and bring it into federal court. And at the time, as we talked here on this broadcast, a federal judge in the Southern District of New York, his name is Judge Alvin Hellerstein, made quick shrift of the decision. And basically, he said that the position of the defendant, Donald Trump, and his attorneys trying to get this case into federal court on the basis that somehow it is all about official acts of a president, simply unsupported. And Judge Hellerstein had no difficulty in saying that the request is baseless. He said the actions here, as alleged in the charges in state court, the actions that are now the focus of the confirmed judgment of guilty by this jury were private. They were unofficial acts, have nothing to do with what the Supreme Court said in connection with a president's capacity to commit crimes. He said they're outside of anything contemplated by the Supreme Court. And for that reason, Donald Trump's position in support of getting the case from state to federal court had to be rejected. Along the way, again, Judge Hellerstein finding very quickly, Jess, that there's no there. This is not a difficult issue, again, because of the fact that we have a private person engaging these behaviors, non-official acts of a presidency that doesn't exist at the time, and for that reason, making that finding a finding that we anticipated, you and I and others in America, that Judge Merchan would be making, maybe with equally short shrift on this past Tuesday, which he did not do.
Well, the thing that just astounds me, Donald Trump was not president.
He wasn't president.
So what is the holdup here in saying, yes, we have a Supreme Court ruling that regardless of that being right or wrong, should not apply.
Just simply doesn't apply.
Simply does not apply.
The defined focus of a defendant has got to be a president of the United States of America. That's your point. That is the point that Judge Hellerstein understood. You should be on the federal judiciary yourself, Jess, one day. And you will join Judge Hellerstein in that common sense approach to this. And it really is the position that's been making the rounds inside of legal circles ever since this particular issue came up. Not a close call. Indeed, Alvin Bragg, the DA, has taken the position from the very start that there's nothing about this case that needs to be thwarted, needs to be stopped. He said that the immunity ruling has no bearing on this case. The Trump cover-up of the sex scandal is unrelated to his presidency. And Justice Merchan, again, called a justice in the New York system, Judge Merchan, poised to rule on that matter simply and straightforwardly. He decided instead not to do so, surprising everybody, including me. Instead, he has some letters in front of him. Let's talk about what those letters say. In a recent letter to the DA's office, counsel for Donald Trump, as a part of their advocacy, which they should do. They should represent the defendant, Donald Trump, as aggressively and effectively as they possibly can, which plainly they have been doing. Requested the prosecutors proactively move to dismiss the case. They argue that as defense counsel, that doing so would avoid, in their words, unconstitutional impediments to President Trump's ability to govern, citing the complex, sensitive, and intensely time-consuming presidential transition process. Now, that may be the case, once again, if we were talking about a sitting president. Right now, yes. Donald Trump, as you just indicated, Jess, as we all know, is a private citizen.
Yes, he is.
And he'll be so by my calculation. I'm not good at math, as you know, but I think it's 58 more days from this weekend on.
Quite nearly 2 months.
Quite nearly 2 months. Plenty of time, and this is the point. Plenty of time, not only for Juan Merchan now in the wake of the election. The reason why he postponed this up to this time did not want to affect the election. You have not done that, Juan Merchan. You have not presumably had an effect. Now you can sentence this defendant, and you can do so while he's a private citizen. For what it is worth, the practical aspects of this, it is not a weeks-long jury trial. reason to believe that Donald Trump has a residence in New York. You can schedule this on for, say 3 hours, 4 hours, whatever you want to, maybe a full day, if you need to afford the defendant a right of allocution to tell the judge what he thinks should happen here, give the prosecution an opportunity to argue how the case should be sentenced. You can get this done well within 1 day, 1 business day. And then what happens? The judge, as a judge would do in virtually any case like this, would stay or tell the defendant, you don't have to go to prison if, in fact, that's what the sentence is. I will not execute whatever the sentence is. Could be probation, maybe a fine, maybe some other things.
Community service.
Whatever the judge may impose at that time, the judge has the complete capacity to say, that's my judgment. I'm concluding my involvement in this as a sentencing judge. Now you're going up on appeal. If you'd like to do that, Donald Trump will. Mm-hmm. And while that appeal is pending, Judge Merchan can and should have said, while that appeal is pending, nothing about my sentence will go into effect. That can be stayed for the coming year while the appeal goes ahead before the New York Appeals Court, before the next year while it goes in front of the New York Supreme Court. And indeed, if at some point down the road the United States Supreme Court decides to exercise jurisdiction, wants to grant a writ of certiorari, getting us well into maybe a third year, which is a long period of time, all that can happen. All that can happen while what? Well, Donald Trump is the president of the United States of America.
Yes.
And he can be represented not by the attorneys he's now appointing to be in the Department of Justice, but by other attorneys who can pursue that appeal on his behalf. Will not in any way obstruct the conduct of the presidency. Maybe they need to consult with him, but an appellate process does not require the defendant to be present at the appellate argument, at the filing of documents, of the briefs, those kinds of things. And so this notion that somehow this is going to affect the future presidency is exactly what Tim Snyder railed against when he talked once again about anticipating the future and obeying in advance, anticipating something that will happen, and therefore teaching power what it can do. That's the Timothy Snyder problem with all of this. Instead of doing that, what Juan Merchan did was equally stunning. He said, you know what, I'm not deciding anything related to immunity, and I'm taking that November 26th sentencing date off the calendar, and I'm doing nothing. I'm imposing no future scheduling deadlines, and in fact, he said nothing when he did all of this. He also received a letter from the district attorney, Alvin Bragg. Here's what Alvin Bragg said. He said, the people deeply respect the office of the president, are mindful of the demands and obligations of the presidency, and acknowledge that defendants' inauguration will raise unprecedented legal questions. What are those? I don't know. He also said, we also deeply respect the fundamental role of the jury in our constitutional system. And yes, indeed, that's Alvin Bragg saying to you, we have gone down this road. A jury threatened during the course of these proceedings, devoted weeks of their lives, court staff, witnesses, the entire mechanism of the judicial system contributed to this result. And now what we do in America, after you are done with that, after a jury does its duty, either acquitting a defendant, maybe sometimes hanging, not coming to a verdict, but in this case, finding the defendant guilty, what do we do in America? All of us know. It's the S word. We sentence, right? And you can do that at any time now. You've got sufficient time. You have had sufficient time since July 11th, since September, and since these days right now. Interestingly, here's the way that the New York Times posted on this particular conundrum. It is curious. The New York Times, I generally regard with great regard and respect. Here's what they said. The district attorney has limited and unappealing options for responding to this request from the defense for the dismissal of the case. They wrote this: he could have either dropped the case, a move that would have voided the jury's verdict, probably alienating, as they said, many people, absolutely right, or suggested some way to pause it, potentially intensifying Donald Trump's ire and drawing some legal challenges. Well, members of the New York Times who wrote that, there's a third option. It's the normal one. It's the traditional one. It's the one that's contemplated by New York procedure, federal procedure, every procedure in the criminal courts of America, and that is to sentence a defendant in a timely fashion. We've now waited 6 months, and that is why this is so very upsetting. And that is why one has to wonder out loud, what is going on here? Why is it that this has happened? Why is it that Judge Juan Merchan did not simply make the decision that I'm going to bring this to conclusion? Donald Trump, you can appeal me on all of this, including the trial, jury selection, evidentiary rulings, but I'm going to conclude this now before Donald Trump takes the oath of office. We'll talk more about that and talk about the other cases also affected by the Supreme Court ruling and by this continuing sense of a need to defer and to bring all these to conclusion as Amicus, a law review, continues. This is Amicus, a law review. My name is Jim Santel. Thank you for joining me in our weekend broadcast. Also joining Jess, my terrific producer, as we talk and try to make sense of what's going on in America. The administration of justice, at least in the Manhattan courtroom, but also at least 3 other courts around the country, which we will get to. The prosecution saying by virtue of this letter to Juan Merchan that there are some competing interests here, the jury's verdict on the one hand and the office of the presidency on the other hand, effectively bringing politics inside the courtroom. And the question that we ask is, what competing interests? Only in the narrowest sense, because, of course, elections and jury verdicts, both essential parts of our rule of law system, both essential parts of our democracy, they can stand apart. One does not supersede or replace the other. There is instead the court's basic duty to uphold the integrity of our criminal justice system, the rule of law, an obligation, I would argue, that is more important now than ever. More practically, why, as many people have argued, should any citizen put up with the sacrifices of service on a jury if the verdict in the end will mean nothing and will be subordinated to the defendant's convenience, even if that defendant happens to be the President of the United States of America? In the wake of that kind of common sense argument, the DA in this case has instead proposed not the normal and traditional sense of going ahead with sentencing. Instead, they have raised the prospect of a 4-year freeze, F-R-E-E-Z-E, a freeze, as a preferable alternative to a dismissal. Defense obviously wants this case to go away completely. Alvin Bragg comes back and says, no, it doesn't have to be dismissed. Let's simply freeze it until 2029, highlighting the need, as Alvin Bragg said, to balance these competing constitutional interests and failing to define exactly what those are. Well, let's think about that once again. 2029, then we postpone all of this until 2029, and after Donald Trump finishes his next term as the president. At that point, this case can return to Juan Merchan 4 years later and be sentenced, be the subject of a sentencing proceeding at that time. In the wake of that, then all of the appellate rights attached to Donald Trump through his counsel, who again cannot be attorneys who are also now inside the Department of Justice. And at that point, 2029 becomes 2030 on appeal, and that becomes 3031 going up to the New York Supreme Court and maybe to the United States Supreme Court, just maybe in 3032.
Wow. And if my math is right here, and now I know they say don't do math on the radio, but that puts Donald Trump at the age of 82 when he leaves the White House, meaning sentencing could now be taking him up to the age of 86.
That's the math that I follow, too. I'm not good at math, as you know, but it seems to me that that is also a consideration, right? And it underscores the overall broad perspective that justice should be expedited to the extent it can be. On behalf of whom? On behalf of the defendant. Defendants in the federal system, the state system, they have a right to a speedy disposition of the charges brought against them by the government. And yes, indeed, the people of the nation, the people of the state have a right to some expedited resolution.
Well, this is why we have this saying that I believe you brought up when you joined us on the Dom Salvia show. Justice delayed is justice denied, especially in a case like this where justice keeps getting kicked further and further down the road, because we see that is the pattern that happens. It's not that justice is delayed for a day. Justice is delayed indefinitely.
Indefinitely. And the stunning part of that indefiniteness is that in taking all of this off of his calendar, for reasons that have prompted me to be scratching my head these days, Juan Merchan has not given us a reason. Previously, he told us that the reason for his delay was because of the Supreme Court opinion. We get that. In September, he said, well, gee, now we're in the middle of a campaign, and now we just took it off his calendar. Presumably, he's looking to the fact that this defendant, this extraordinary defendant, will soon be the president of the United States of America, again, running afoul of what Timothy Snyder tells us in not anticipating the future. When you adapt your policies, your procedures, your behavior, you are teaching power what it can do. That authoritarianism, if it comes, is freely given. In this case, I would offer, as much as I respect Judge Juan Merchan, he's an outstanding jurist, as much as I respect Alvin Bragg, who has brought this case against all odds, in this particular instance, they are running afoul of that notion that justice delayed is justice denied. Justice delayed is justice denied. And by obeying in advance, you are compromising those fundamental rule of law principles. That happened just this past Tuesday. We do not know. The case is still pending. We do not know what will happen in the next 58 days or so, or even beyond that. Presumably, Judge Juan Merchan will choose between these two alternatives. The two alternatives which are either dismissing the case outright before sentencing, rendering that jury verdict completely irrelevant, or he'll do this other very peculiar thing, the Alvin Bragg freeze, and we'll extend all of this. We'll put this file on the shelf for the next 4 years and then resume actions in 2029.
Do you think that there is any chance at all, that Judge Merchan will actually say, no, we are going to do a speedy, we've been dragging our feet, but now we will have a speedy disposition of justice. Now we will have a quick sentencing, sentence him to 30 days.
Right. Do something, right? Sentence something to close this case out. The answer is yes. You like to think that Judge Merchan, he is a bright guy. He is a good jurist. He knows what he's doing. He presided over this trial with great experience and great capacity. And there's no question about that. My guess is he is doing some head scratching of his own right now, wondering what to do, but hopefully also recognizing that he's got three choices, these two bad choices, and he's got the third choice, which is the normal one.
Yes.
And maybe just we can be broadcasting about this in the future and saying, indeed, justice, although delayed, was not denied here. And again, the disposition of this case can go forward even during the days, weeks, months, and years ahead of this presidency without compromising in anything related to some unprecedented legal questions about which the district attorney speaks. That result, that Tuesday surprise, if you will, was joined by other things that we've talked about in the past. We know the federal cases, especially running afoul of that notion of not obeying in advance. The federal cases, that is the Mar-a-Lago case, the documents case, and also the federal insurrection case, that is in Washington, D.C. In both of those, as we know well, the special counsel has moved the court to suspend everything, take the deadlines off, and indeed both courts reviewing those cases have done just that. When we come back, we'll talk more about, again, the imposition of resolution in these cases and the notion that justice can, in fact, be accomplished in the future as Amicus continues. This is Amicus, a law review. My name is Jim Santel, talking all about the administration of justice this weekend on our broadcast and advancing the proposition that an election, even the election of a president of the United States of America, is no reason to undermine and reverse the normal course of the criminal justice process. No reason in this case to postpone Donald Trump's felony sentencing. None whatsoever. We know as well that in those federal cases, we're approaching on a different plane, different mechanisms, different circumstances, pretty much the same result of these cases dying with a whimper. We know that the federal case pending in front of Judge Tanya Chutkan, that's the federal insurrection case, has also, upon the motion granted by the judge to suspend everything there, to cancel all the proceedings, to cancel all the deadlines, and Judge Tanya Chutkan has done just that, even though, again, 58 days during which she could also issue her opinion on a like case, a like situation, whether or not that Supreme Court case requires her, as to the federal case, does it require her to abandon the case, to dismiss it? It's a tougher question. It is a closer question because, again, we're talking about a sitting president, but it's one that she has promised to deliver. And plainly, by granting the motion of Jack Smith through the Department of Justice, she has all but signaled that decision, as we talked about in our broadcast last week, and will never come. Similarly, the other federal case, we know that that's pending right now in front of the 11th Circuit. Why? Because there, Judge Eileen Cannon out of the Southern District of Florida made this unprecedented and unfounded decision that Jack Smith did not have the authority to prosecute the documents case, the classified documents prosecution there against Donald Trump and others, including some obstruction of justice charges. And so Jack Smith initially took that up on appeal to the 11th Circuit. And as recently as just the past couple of weeks, filed a motion there and said, you know what, 11th Circuit, why don't you suspend everything here? Take off any of these deadlines. We'll get back to you, both in Washington, D.C. and also in the 11th Circuit, which is Atlanta. We'll get back to you by December 2nd. That's the deadline. Now established in both of those cases, both of the federal cases, both of them with suspended deadlines, rejected and rescinded deadlines of all kinds. No hearings going forward based upon the granting of these motions in both of those cases. And finally, just this past week, consistent with these other three matters, the Manhattan case, in which now we have the likelihood of no sentencing at all, no resolution there. The federal insurrection case, in which, again, it's entirely possible that the United States Department of Justice is going to dismiss that as well, anticipating the presidency of Donald Trump, likely going to dismiss the documents case as well, again, anticipating that he will be one day president, and doing that based upon a principle inside the Department of Justice that says you can't prosecute a sitting president, even while that person is not presently the president, applying that proactively, assuming that will happen, and it will. But right now, in the 58 days, deciding not to seek some, at least partial, resolution of those cases. And so, again, obeying in advance and telling power what it can do in the future. More of that in Georgia. Curiously, just this past week, the Georgia case now also on appeal to the Georgia Appellate Court without any comment, without any explanation, just like Judge Juan Merchan in New York. The Georgia Appellate Court took off its calendar the scheduled oral argument in the appeal in that case as well. You may recall well that appeal was a challenge by the Trump defense team to the decision by Judge Scott McAfee to keep Fani Willis on the case. Also, Fani Willis had appealed the decision by Scott McAfee to dismiss about 6 counts of the omnibus indictment against Donald Trump and others. All that pending in front of the Georgia State Appellate Court. Just this past week, the appeals court there issues an order, a directive on its docket saying, we're not going ahead with anything further. The appellate argument taken off the calendar, not based upon any articulated statement. And that, as we head into late November and into the Thanksgiving holiday and other holidays coming up, in the lifeblood of our nation in December, and certainly looking into the January period when we will be inaugurating a new president of the United States of America. That is the status of these cases in state and federal courts in our land. All, as I said, dying not with some disposition, not with even interim dispositions as with respect to the federal cases, getting those decisions from the 11th Circuit and from Judge Chutkan that can define the future, even though those cases will never go to trial. Those things are important, as I have argued previously. The Georgia appellate case, plainly, Fani Willis still very much interested in appealing that and pursuing that appeal, but being told, at least just this past week, that the oral argument will no longer go ahead. We don't know what that means. Would the appeals court there do something different down the road? Possible. Maybe they'd already made up their mind on all this appeal and don't need oral argument. That's a possibility. Most likely they too are anticipating the future when one of the defendants there, his name is Donald Trump, will become the president of the United States of America. The difference there, of course, is that you have many other non-presidents who are also defendants in that case. And even in the Mar-a-Lago case, two other defendants joined with Donald Trump on obstruction of justice charges. What do you do with those? What's going on in the 11th Circuit? What's going on in the Georgia Appellate Court? What's going on in the District Court in the District of Columbia? And what has happened just this past week in the Manhattan Criminal Court? That is, at least for now, going in the direction of no sentencing for a defendant found guilty by a jury unanimously, beyond a reasonable doubt, of violating the criminal law in the state of New York. Needless to say, an awful lot of frustration, a lot of concern about all of these cases going away. Once again, a citizen who adapts in this way is teaching power what it can do. Power also the subject of things going on overseas and some lessons coming from rule of law events happening in Brazil and Hong Kong and France. Let's talk about those, Jess, as well. Let's begin with this other news coming from this hemisphere, but to the south of us, this coming out of Brazil. Brazilian authorities just on Thursday of this past week announcing that they are recommending criminal charges against former President Jair Bolsonaro. Over what? Over his role in a broad plot to stay in power, to cling to power after he lost the 2022 presidential election.
Oh, goodness.
Sounds familiar, does
Very
it not?
much so.
Right? The current president, his name is Luiz Inácio Lula da Silva. He has refused to acknowledge that Bolsonaro has refused to acknowledge that the actual president, Mr. da Silva, has taken the position of the presidency, a legitimate election there, and Bolsonaro refusing to acknowledge defeat. And as a result of that, in the investigation that has followed, again, a different system there, the police have urged prosecutors to charge the former president, Bolsonaro, and 36 others, including members of his inner circle, for crimes, according to their recommendation, the violent abolition of the democratic rule of law, a coup d'etat, and criminal organization. All of that coming out of charges recommended, again, in their system by the police, now going on to prosecutors to determine whether or not those charges should, in fact, proceed. After a 2-year investigation in which police raided homes and offices, they arrested senior aides to Bolsonaro and secured confessions and plea agreements as to some of this along the way. The police also said that there was evidence that Bolsonaro had overseen this broad conspiracy based upon the results of their investigation, planning the arrest of a Supreme Court judge, personally editing a draft decree aimed at overturning the election results, and presenting the coup plans to top military leaders seeking their support. Sounds like an attempt to overthrow the government.
Indeed,
when you have
does.
left government itself again. Shades of what we have seen charged also here in America, but not the result of any conviction.
Yes.
As Amicus continues, we'll tell you more about that very interesting recommendation for charges against a now former president. More about that, and then also lessons from Hong Kong and also other things in our future with respect to other matters pending here in the United States of America. So what exactly is it? What exactly is it that Bolsonaro is also accused of in prior matters, also recommended by the police in Brazil? In prior matters, he is recommended for prosecution for attempting to falsify COVID-19 vaccination records throughout the nation.
Oh, that's not ideal.
It is not ideal. Again, compromising the health, the safety of his nation, and also a plot. Get this, a plot? Curious? To embezzle jewelry that he received as gifts from foreign leaders while in office, as if all of this is not enough, embezzling some jewelry also. Mr. Bolsonaro, just for good measure, will throw in some theft of a piece of a gift, plainly from foreign leaders. How is that possessory interest, as they say? How should that be understood? That's in the possession of the people of Brazil. It was given to Bolsonaro not in his private capacity, but as a gift to the people of Brazil. Again, charged or are proposed to be charged by the police. That also pending as to Bolsonaro. All of this also, again, now in the hands of the top prosecutor. His name is Paulo Gonet, and he has to decide whether to pursue these charges against Bolsonaro and the others as a result of this investigation. All of this, of course, comes in the wake of something else that's very similar to what happened here in the United States of America. Jess, you and others will remember well this episode reminiscent of the attack upon our own Capitol when supporters of Bolsonaro invaded and then vandalized Brazil's Congress, their government building, the Supreme Court, presidential officers just days after the incoming actual president, Mr. Lula, took office. And they were hoping, of course, to provoke a military intervention at that time.
They were hoping to provoke a military intervention.
Yes, right. Get the army to join us in this attempt to overthrow the government, even while we are attempting in this very event.
And it sounds like, fortunately, that was not successful.
It was not successful, as it was not successful in the end here in the United States of America. And as a result of all of this, as if Mr. Bolsonaro's problems are not serious, in June, just a number of months ago, there's a thing called the Electoral Court in Brazil. And the Electoral Court has barred Bolsonaro from running for office. That's a good thing, I suspect, until 2030. And it ruled that he had violated the law when he summoned diplomats to the presidential palace. And he made some baseless claims to them that the nation's voting systems were rigged against him.
Familiar
once again. Similar. There you have a law enforcement set of principles going forward. We'll see what the prosecutor does with respect to all of those. They're a former president, plainly in trouble with the judicial system. And we will continue to watch that. Lessons about what the rule of law can and should do. Mr. Bolsonaro plainly presumed innocent until proven guilty, if at all, by a jury there in Brazil. That is a democracy. They have the same kinds of trappings that we have in that nation, at least. And that nation there, the authorities, the police, and presumably the prosecutor looking at all of this at some point will embrace the rule of law and say, we need to proceed with this because it is right and is decent. As you have said before, Jess, it is the right thing to do as people involved in government. That happening in Brazil just this past week. And then we've got more lessons coming in from overseas. And this one happens to do with what happened in Hong Kong. Pro-democracy leaders sentenced in a mass trial just this past Tuesday. As Amicus, a law review, continues, we'll tell you what happened there and what happens in an authoritarian state that it wants to bring to a conclusion voting and advocacy against the government. We'll talk more about that as our broadcast continues. This is Amicus Law Review. My name's Jim Santel. In the last minutes of our broadcast this weekend, going overseas to draw some lessons about what we should think about our own nation in connection with the rule of law. In Hong Kong, just this past Tuesday, a Hong Kong court, 3 judges who were appointed, placed in those positions by, the Beijing government, by China, sentenced 45 former politicians, activists in a mass trial that decimated and destroyed the Hong Kong's once very vibrant pro-democracy opposition and served as a warning, basically, that resistance to Beijing can be very costly. It's what happens when, indeed, an authoritarian government decides that they no longer want to entertain even the possibility of protests in their nation, in the city, in that particular case. The offense, according to the trumped-up allegations there, according to the authorities, holding or taking part in an unofficial primary election. What is this all about? Well, again, the facts coming out of this very, very skeletal proceeding here that resulted in the convictions and the sentencings of 45 people is that this pro-democracy camp, this group of people, has said that they put together a primary vote, very similar to what other primary elections had been there, as a part of their attempt to invest in the legislative chamber there some people who are of their own view. More than 600,000 people cast votes in this primary election. They were choosing candidates who were prominent supporters of the anti-government demonstrators. And as a result of that, the government clamped down and said that is not only contrary to what we will do here in Hong Kong, but to stop you from doing that in the future, we're going to charge you with criminal offenses. And this past week, in this authoritarian government, a sign of what an authoritarian government can do if it gets rid of the fundamental trappings of justice, including due process, including investigations that are legitimate, telling people what they're charged with, giving them an opportunity to engage in a proper defense. If all of that goes away, you see what happened this past week in Hong Kong. In one fell swoop, the authorities arrested a number of years ago all sorts of people, legal scholars, opposition strategists, pro-democracy activists, younger politicians, older politicians, people who were advocating for freedom in Hong Kong, again, now overseen by Beijing, now jailed for anywhere between 4 and 5 and 6 and 8 and 10 years in some cases for their advocacy there in Hong Kong. All of this, again, coming after prosecutors accusing the defendants of conspiracy to commit subversion, some national security offenses, arguing that the objective of this election primary, which was held way back in 2020, was to undermine, destroy, and overthrow the existing political system and the very structure of Hong Kong. Those are words, those are charges that come from an unfettered authoritarian government. And today, people are in prison for years and years in the future based upon their interest in having voting and permitting people to go to the voting places to elect representatives who represent them. There is the lesson for America. If indeed any administration in the future, at any time in the future, we cede authority to an authoritarian who says, you know what, we don't need to do any of those trappings of justice. Instead, we'll just move right to a trial and will result in the sentencing of people. We'll send them to jail. That is a lesson coming from Hong Kong. Plainly, an awful lot of civil rights responses to that, human rights responses, cries to the Beijing government to reverse those actions, probably falling on deaf ears. And finally here in our weekend broadcast, returning to a story that Jess first recommended to me a number of months ago, because
feels like years.
Because of the seriousness of it and also the importance of what trials can do. This is a case involving a defendant and many, many others. 51 men altogether on trial, mostly for accusations of an aggravated rape of a woman named Gisele Pelicot. Her husband, Dominique Pelicot, has admitted to crushing sleeping pills into her food and drinks for almost a decade. And then, stunningly, shockingly, inviting dozens of men he met online into their home to to rape her alongside him while she was unconscious. This past week, the trial continues. Again, a trial in which the result is probably known. The importance of a trial and affording all victims opportunities to be heard. Not only Gisele Pelicot, who has become something of a national icon, she is a woman of incredible strength in the wake of this horrific thing that has destroyed her family. And that's the point of what has happened just this past week. As a result of the continuing trial there, the family members of Gisele Pelicot, her family, and of course, Dominique Pelicot have taken the stand. And the oldest son, for example, it was the whole family, he said, in a dramatic day of testimony there. A whole family that has been devastated by what has happened here. You need to know that this trial is a trial of a devastated family. David Pelicot, who himself, he's the son, is haunted, he said, by fears that his own son, who remains in psychological treatment, was also abused by his grandfather. His sister, who goes by the name of Caroline Darien, we also talked about her, a shadow of her former self. She also testified about concerns that her father may have done the same thing. She is convinced that she was also drugged and sexually abused by their father. A youngest sibling, Florian, took the stand to say that his marriage has collapsed as a result of this, cost me a divorce and thousands of questions. Absolute, abject meltdown tragedy. And in France, a system that permits at least their voices to be heard in this all-important trial that's going on, these defendants will go away to jail for the rest of their lives, as well they should, for this absolutely heinous event. The aforementioned there in France of a system of justice that permits trials to complete and to go to jury verdicts, which will come based upon the admissions and based upon the other evidence being presented, all of that a lesson to America, again, about the importance of investigating cases, of affording victims and others involved in these cases the opportunity to be heard, and the possibilities of justice imperfectly being doled out to a nation and to a family plainly devastated by criminal conduct. A lot to consume here on Amicus, a Law Review. A lot of lessons to be taken from overseas and also from our own nation about the importance of the rule of law and justice, the ways in which courts should indeed behave and conduct themselves to ensure that all of us understand the importance of due process and ensuring that justice is done for all of us. As we go forward in future broadcasts, we'll continue with that theme. Stay with us for those broadcasts as well. Have a good weekend, everybody.
The national news cycle never stops, but it can be hard to find news about your local community. Civic Media is dedicated to providing quality local and state news coverage across Wisconsin. With the Civic Media app, you can get notifications about local stories that matter to you and your community. Find the free Civic Media app in your phone's app store and choose notifications from the menu to tell us what kind of news you want to hear about.